When I see quotes like I did today from someone named Dan Pfeiffer, who apparently works for the president. I think it's the same Dan Pfeiffer that once said the law is irrelevant. And he tweeted out today that our plan is to allow some kids to stay but deport their parents. He summarized this entire debate with that tweet. So I want to compliment you and thank you for not being a demagogic, self-serving political hack who can't even be elected to a parent advisory committee, much less Congress, which is what Mr. Pfeiffer is. I want to thank you for not being that and understanding these are complex issues where reasonable minds can perhaps differ. And with that, on behalf of all of us, thank you for contributing to this issue.
Facts directly contradict the statements you made on national television this last Sunday.
No, sir. With all due respect, they do not. We just heard email after email after email about Libya and Benghazi that Sidney Blumenthal sent to the Secretary of State. I don't care if he sent it by Morse code, carrier pigeon, smoke signals. The fact that he happened to send it by email is irrelevant. What is relevant is that he was sending information to the Secretary of State. That is what's relevant. Now, with respect to the subpoena, if he'd bothered to answer the telephone calls of our committee, he wouldn't have needed a subpoena.
Would the gentleman yield?
I'd be happy to, but you need to make sure the entire record is correct, Mr. Cummings.
And that's exactly what I want to do.
Well, then go ahead.
I'm about to tell you. I move that we put into the record the entire transcript of Sidney Blumenthal. We're going to release the emails. Let's do the transcript. That way the world can see it.
Well, we didn't.
The motion has been seconded.
Well, we're not going to take that up at a hearing. We'll take that up in a business
I've consulted with the parliamentarian, and they have informed us that we have a right to a recorded vote on that motion. We want, you ask for the truth, the whole truth, and nothing but the truth. Well, that's what we want to have. Let the world see it.
Why is it that you only want Mr. Blumenthal's transcript released? Why don't you want the survivors?
All of them released.
The survivors, even their names?
Let me tell you something. No,
you want that released?
Let me tell you something. Right now,
the only one you've asked for is Sidney Blumenthal. That's the only one you've asked for. That and Miss Mills.
Cheryl Mills.
That's not true.
No, that's 2 out of 54. Now, if you want to ask for some fact witnesses,
we asked for a recorded vote on the Blumenthal. You said from the beginning we want the truth, the whole truth, and nothing but the truth. Why don't we just put the entire transcript out there and let the world see it? What do you have to hide?
His are the only emails that you have released. And the fairness to Mr. Blumenthal and to the American people, in the interest of a complete record, if you're going to release his emails, release his transcript where he has a chance to give the context of those emails.
Well, you keep referring to Blumenthal emails. I would hasten to remind both of you, the only reason we have Blumenthal emails is because he emailed the Secretary of State. Those are her emails. That's why they were released. They're not Blumenthal's emails, and she wanted all of her emails released. She's been saying since March, I want the entire world to see my emails. Well, Sidney Blumenthal's emails are part of that. For decades, you're good enough to help with drug cases. You're just not good enough to help with immigration cases. You're good enough to help despite the fact that the Second Amendment clearly occupies that field. If you want to talk about preemption, it clearly occupies the field. Title 18, 922G, 924C, all the federal firearm statutes. You're good enough to have your own state firearms laws. You're just not good enough to help out with the immigration laws. And even though the federal system has the Hobbs Act to take care of armed robberies, it's okay for states also to have armed robbery statutes. We don't just tell the feds, you're the only ones who can occupy drugs and firearms and robbery cases. So I'll tell you this. I've worked with state prosecutors and federal prosecutors and state and local law enforcement. If you're good enough to do homicide cases, then I trust you to do immigration cases. And I think it's a shame that anybody doesn't. If you're good enough to investigate the most serious crimes in this country, but yet we're worried about you understanding the complexities of immigration law, I've heard a lot about respect for the rule of law. I'm interested in respect for the rule of law. I'm much more interested in adherence to the rule of law, because nothing undercuts the fabric of this republic like people picking and choosing which laws they're going to enforce, when they're going to do it, when it's politically opportune for them not to do it. So I'm happy to talk preemption. I'm happy to talk stare decisis. I'm happy to talk supremacy clause. I'm happy to talk enumerated powers or any other legal concept you want to talk about. What I will not do is let state and local prosecutors and state and local law enforcement be disparaged and say, we trust you to handle homicide cases, but we're not going to trust you to handle immigration cases. That I will not do. I started this debate months ago saying I am happy to find a synthesis between the respect for the rule of law that defines us as a republic and the humanity that defines us as a people. I am happy to do that, to search for that synthesis. But I am not going to pursue the humanity at the expense of the respect for rule of law. I'm not going to do it. Sheriff, you think you're capable of enforcing immigration laws if your jurisdiction decides to pass ones that are not inconsistent with, but consistent with federal law? Do you think you're capable of doing that?
Absolutely, Mr. Chairman. And this is to your point, and I appreciate your remarks, because it quite frankly was offensive to hear that. I have close to 700 men and women that work in our sheriff's office who risk their own personal safety, their lives, and oftentimes for those who are illegal. We do not differentiate. And we have several hundred of my staff who are Hispanic. What are we saying about them? And the fact that we swear an oath to preserve, protect, and defend our Constitution, we put our lives on the line for all people. And the fact that we're in this conversation, this debate today, you trust me, you trust every law enforcement officer in America to deal with not only the most complex issues for U.S. citizens, that we can make life and death decisions, the only profession in our land that can take another person's life. And yet, we're saying here we're not smart enough to be able to ask questions and to call out to help for ICE, which is what we did. We're not asking for something that we didn't have. I only had 13 of my deputies and detention officers who were 287G certified. I've got a full plate in Pinell County. I don't want to do ICE's job, but we should be able to talk together and work in concert together to solve an issue. How did we get to this point that the cops are now the bad guys? And it's because that we as a country, Republicans and Democrats, have failed to address this issue and to solve it. So we're put in the crosshairs and are disparaged. And that, of course, our motivation, and this is one of the casualties of this, the undermining not just of the rule of law, but those who preserve and protect on a daily basis every person's safety.
Well, Sheriff, I appreciate my time is up. If we have a second round, I will get the district attorney to help me understand how city council members in certain cities are smart enough to ignore federal law and create sanctuary cities, but these guys aren't smart enough to enforce federal order and rise in opposition to the motion to recommit.
The reservation is withdrawn and the gentleman is recognized for 5 minutes.
Thank you, Mr. Speaker. I want to talk for just a moment as colleagues, not as Republicans or Democrats, not as members of the majority or the minority, but colleagues who are blessed to serve in the United States House of Representatives, the People's House, with all the tradition, with all the history, with all the laws that have been passed, with all the lives that have been impacted. I want us to talk as colleagues because our foundational document gave us, as the House, unique powers and responsibilities. We run every 2 years because they intended for us to be closest to the people. The president was given different duties and powers. The president was given the duty to take care that the laws be faithfully executed. So my question, Mr. Speaker, is what does that mean to you, that the laws be faithfully executed? We know the president can veto a bill for any reason or no reason. We know the president can refuse to defend the constitutionality of a statute, even one that he signs into law. We know the president can issue pardons for violations of the very laws that we pass. And we know that the president has prosecutorial discretion as evidenced and used through his U.S. attorneys. Mr. Speaker, that is a lot of power. What are we to do when that amount of power is not enough? What are we to do when this president or any president decides to selectively enforce a portion of a law and ignore other portions of that law? What do we do, Mr. Speaker, regardless of motivation, when a president nullifies our vote by failing to faithfully execute the law? How do we explain waivers and exemptions and delays in a bill passed by Congress and affirmed by the United States Supreme Court? How do we explain away a refusal to enforce mandatory minimums that were passed by Congress and affirmed by the Supreme Court? And why pursue, Mr. Speaker, immigration reform if presidents can turn off the very provisions that we pass? You know, in the oath that brand new citizens take, it contains 6 different references to the law. If it's good enough for us to ask brand new citizens to affirm their devotion to the law, is it too much to ask that the president do the same? If a president can change some laws, can he change all laws? Can he change election laws? Can he change discrimination laws? Are there any laws under your theory that he actually has to enforce? What is our recourse, Mr. Speaker? What is our remedy? Some would argue the framers gave us the power of the purse and the power of impeachment, but Mr. Speaker, those are punishments, those are not remedies. What is the remedy if we want the executive to enforce our work? This bill simply gives us standing when our votes are nullified. This bill allows us to petition the judicial branch for an order requiring the executive branch to faithfully execute the law. Mr. Speaker, we are not held in high public esteem right now. Maybe members of Congress would be respected more if we respected ourselves enough to require that when we pass something, it be treated as law. Maybe we would be more respected if we had a firmly rooted expectation that when we pass something as law, it be treated as law. Maybe we would be more respected if we put down party labels and a desire to keep or retain or acquire gavels and picked up the history, the tradition, and the honor of this, the people's house. Mr. Speaker, the House of Representatives does not exist to pass suggestions. We do not exist to pass ideas. We make law. And while you are free to stand and clap when any president comes into this hallowed chamber and promises to do it with or without you, I will never stand and clap when any president, no matter whether he's your party or mine, promises to make us a constitutional anomaly and an afterthought. We make law. All facts necessary or that would be at the disposal of this committee are already in the record. Ms. Lerner is not coming back. And Mr. Chairman, I don't need law professors to come for a second hearing and read me the case law. There's not going to be one additional fact uncovered at a second hearing. So what facts do we have at our disposal? Mr. Chairman, I have identified 9 separate specific assertions made by Lois Lerner on May the 22nd. And that was after she asserted her right against privilege. 9 separate factual assertions, including, Mr. Chairman, I have done nothing wrong. I have broken no laws. I have provided no false information to Congress. I have violated no IRS rules. I have violated no IRS regulations. And then, Mr. Chairman, she authenticated a document. All of this, Mr. Chairman, after she invoked her right to remain silent. 9 separate factual assertions and the authenticating of a document after, with the advice of counsel, I hasten to add, with the advice of counsel sitting right behind her, she testified to 9 separate factual assertions and then authenticated a document. So, Mr. Chairman, the case law to me is clear. That is not the way the Fifth Amendment works. You don't get to tell your side of the story and then avoid the very process that we have in this system for eliciting the truth, which is cross-examination. Why do we have a confrontation clause? To my colleagues on the other side of the aisle, why do we have a confrontation clause? Because cross-examination is the best technique, the best tactic for eliciting the truth. And every witness has to sit on the stand, and they have to weigh and balance. What are the benefits of saying nothing, which is my right? Or what are the benefits of getting my side of the story out? That's what you have to balance. Saying nothing versus telling your side of the story. But, Mr. Chairman, there is no contemplation in the Constitution that you tell your side of the story and you're never cross-examined. And the Supreme Court agrees with us. Mr. Chairman, these are just 2 quotes from the Supreme Court. A witness may not testify voluntarily about a subject and then invoke the privilege against self-incrimination when questioned about the details. Similarly, in Brown versus United States, a witness waives the privilege by voluntarily giving exculpatory testimony. A denial of activities that might provide a basis for prosecution constitutes a waiver of that privilege. Yes, she has a Fifth Amendment right to remain silent. She sat there and could have said nothing. We had a witness this week who did that. We had a witness this week who said nothing. She didn't. She made 9 separate factual assertions, and then she authenticated a document. If that is not waiver, if that is not express waiver, then surely it's implied waiver, and if it's not implied waiver, what is? If giving your side of it, 9 separate facts, and Mr. Chairman, I have to add this. Because aside from certain factual assertions, this witness volunteered, and this is important, she testified that she has done, quote, nothing wrong. I know my friends on the other side of the aisle will conclude that is an amazingly broad statement. It's tantamount to a double negative. I've done nothing wrong. So let's flip it around. What she's really saying is, I have done everything right. To say I've done nothing wrong is to really say I have done everything right. So, Mr. Chairman, what possibly could be a broader assertion of fact than to say I have done everything right? I want to say this in conclusion because my time is almost up. I have had private conversations with colleagues on the other side of the aisle whose opinion I respect very much. And I'm not going to disclose those private conversations other than to say I benefit from their counsel. There's some very, very good attorneys on the other side of the aisle, as there are on this side of the aisle. The way I view this, Mr. Chairman, is this is Congress asserting its constitutional obligation to provide oversight. Yes, she has a constitutional right to remain silent, and she could have invoked it, but she did not. And we have a constitutional obligation to provide oversight. So we can have another hearing. I have great respect for the gentlelady from the District of Columbia, but let's be honest with each other. There's not going to be one more fact that's part of this record. Not one. We're going to bring a law professor to say that she waived. You're going to bring a law professor to say that she did not, and we'll be right back where we are today. All the facts that we're going to have are here right now. 9 separate factual assertions. If that is invoking your right to remain silent, then there's no such thing as waiver. If they weren't work-related, or did they not find them?
Well, I don't know why he had emails I didn't, and I don't know why apparently I had emails he didn't. And all I can tell you is that I turned over every work-related email in my possession.
All right, I'm going to make 2 more observations, and then we're going to call it a night. The first observation that I would make is that when you speak to the public, you say, "I turned over everything." That's, for the most part, a direct quote. When you talk to the public, you say, "I turned over everything." When you talk to the court, you say, "While I do not know what information may be responsive for purposes of this lawsuit, I have directed that all my emails on clintonemail.com in my custody that were or potentially were federal records be provided to the Department of State, and on information and belief that was done." Why the different explanation depending on who you're talking to?
Well, one is a shorthand, Mr. Chairman.
Well, why not just tell the court, "I turned over everything"?
Well, you know how lawyers are. They use more words perhaps than they need.
Trust me, I know that, and they charge you for every one of them.
Yeah, I'm well aware of that, Mr. Chairman, and the clock is ticking.
Well, one more, and I'll pay Mr. Kendall's fee for the last question.
Oh, I don't think you want to do that, Mr. Chairman.
I probably can't do it. You see my point, though? You're very definitive when you're talking to the American people that you turned over everything.
That's right.
But there are those kind of lawyerly fudge words when you're talking to court on information and belief.
Well,
and the reality is, even tonight, you cannot tell us that you turned over everything because you didn't think you missed the 15.
Well, I didn't have them. I turned over everything I had. Everything I had has been turned over to the State Department.
Somehow missed those 15.
Well,
last question on your system. Mr. Cummings said that your email arrangement was inappropriate. I think the president may have said it was a mistake. You have said that it was a mistake. My question to you, Madam Secretary, is was it a mistake for the 4 years that you had that email arrangement? Was it a mistake almost 2 years that you kept the public record to yourself, or has it manifest itself as a mistake in just the last 6 months?
Well, since I believed that all of my work-related emails to .gov accounts were being captured and preserved, it wasn't until I was asked to help the State Department to fill in what they saw as some record-keeping gaps, not just with me, but with others. I did the best I could during those 4 years and thought that everything that I was emailing that was work-related was being preserved.
If you can find the source for the 90 to 95%, I would be grateful for it, and we would probably have fewer questions. You've had a good life. You have time to say goodbye to the people you love. You have time to offer a prayer for your soul. It just walks slowly and knocks gently on the front door. And then sometimes it kicks in the front door unexpectedly with no notice, and you don't even have time to offer a prayer. And the word closure is used all the time. In my experiences, it's only used by people who have never suffered the loss of a child, because there is no closure. I can't offer you closure. What I hope we can offer you is the truth, facts, justice, and let you do with that what you need to do as you walk down that road we call grief. So we can't give you closure. It's the facts, the truth. And the real jury, Mr. Woods, Ms. Smith, is the American people. They're the ones watching this trial unfold, and they will decide. They heard this morning a perspective that everything that can be investigated has been investigated. Everything. That's one perspective. The other perspective is you didn't even bother to interview some of the central key eyewitnesses. And the American people are going to have to decide whether or not they would ever tolerate an investigation where you don't call eyewitnesses and you don't call the people responsible for whatever the duty was. But I want to leave you with this. I want you to know this. From the upstate of South Carolina, I am asked about Benghazi more than any other issue. It has not been forgotten. I suspect you both live a long ways from the upstate of South Carolina. But just know, Republican, Democrat, Independent, don't know, don't care, from church to the grocery store to Costco, frankly to the golf course, I am asked about Benghazi and in effect about your sons more than any other issue. So the jury has not forgotten.